Thank you. Thank you for the hard work you put into this to bring this issue to Senate's attention. I want to give a quote. It just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for years that it takes to go through the normal process, end of quote. Those words are from Justice Kagan, said during a speech 3 years ago. I happen to agree with her. Our hearing today goes by the title of, quote, Rule by District Judge 2, Roman numeral 2, Exploring Legislative Solutions to Bipartisan Problems of Universal Injunctions. I hope that we can continue the discussion from our hearing on the same topic in 2020 and focus on some legislative solutions. For a number of years, but particularly the last few months, we've seen increasingly sweeping orders from individual district judges that dictate national policy. These orders, quote unquote, called universal injunctions, direct the government to take or not take action with respect to persons who aren't even before the court. Although our founders saw an important role for the judiciary, they didn't design a system that made judges national policymakers. They adopted a constitution that strictly limited courts to exercising power of the words that are in the Constitution to cases or controversies. Sweeping universal injunctions defy nearly 2 centuries of historic precedent. For the first 175 years of our history, universal injunctions were unheard of. They've been extremely rare until the last decade. Now we can barely read the news without learning of another district judge issuing an order that covers all 93 judicial districts in the country. It's one thing for a district court to offer relief to parties before it. That's what a judge can and what a judge should do. A judge has authority to resolve a case or controversy, and sometimes that'll include holding that a statute or executive action is unlawful. It's another thing, however, altogether for a single judge to order the government to act with respect to people who aren't even before the court. That reaches far beyond the legitimate authority of the court and becomes policymaking. This is something none of us, Democratic or Republican, should want judges to do. Right now, there are more than 600 active district judges, more than 1,000 if you count senior judges. Any one of them can effectively veto national policy. In one sense, district judges wield more power than any Supreme Court justice who must vote with their colleagues before stopping or compelling national government action. This creates then a strong incentive for form shopping. According to 2024 Harvard Law Review study, nearly all universal injunctions against the first Trump administration and the Biden administration were issued by judges appointed by the opposite political party. This places tremendous strain on the judicial system. Universal injunctions are also unconstitutional. Article 3 of the Constitution tasks the judicial branch with deciding, as you've heard me say, cases or controversies. The Supreme Court has long required judges to engage in detailed analysis to ensure that they have authority over a case. They must determine that a party before them has been injured, that the inquiry is traceable to a defendant's conduct, and that the court can do something to remedy it. Now, judges routinely ignore these constitutional limits and issue orders directing government action for the entire country. In February, a district judge issued an order requiring $2 billion in U.S. aid funding to be paid out within 36 hours. The vast majority of people who never even sued. The Supreme Court had to instruct the district court to narrow its ruling and narrow it significantly. On Monday, a district court in California issued an order in a case involving 7 Venezuelan plaintiffs and an association that advocates for them. Instead of just deciding the case before them, the judge halted the policy for approximately 350,000 Venezuelans under the Temporary Protective Status Program. The district judge had no authority over people who weren't before the court, but single-handedly vetoed a policy that Americans specifically elected President Trump to enact. Some people may ask, if universal injunctions are eliminated, how can plaintiffs get relief, especially in cases where it's hard to represent every person affected by law or order? The federal rules of civil procedure provide a solution: class action. This is a powerful legal tool to offer comprehensive relief, and it also contains protections to preserve the rights of parties that are represented in this unusual way. Universal injunctions shortcut all of that. Eliminating universal injunctions still preserves the important role of the judiciary in a system of checks and balances. Class actions remain intact, and judges retain their awesome power to protect litigants before them from unlawful action. But when a single judge can override the political branches to set national policy, the checks and balances of our country and Constitution are thrown off. We should instead return to the framework established under the Constitution. District courts decide the case before them. The appellate courts set precedent for all courts below them. That's the appropriate check on other co-equal branches of government. Universal injunctions turn the whole thing on its head. Most of us in this room have at various times supported or opposed universal injunctions. My fellow Republicans and I sometimes like them when there's a Democratic president, and my Democratic colleagues probably like them right now, even though they criticized them a few months ago under President Biden. Too often, we accept politics over principle. But the truth is that we all know this isn't how government and the judiciary should operate. It's past time to address this issue. The Supreme Court can and should fix this problem. Unfortunately, they sit on their hands. If they won't act, Congress must act. I propose legislation to fix this problem. I think it's a good solution because, like all good compromises, it probably leaves everyone a little unhappy. We all have to agree to give up universal injunctions as a weapon against policies we disagree with. The damage it causes to the judicial system and our democracy is really too great. I hope today we can have a productive discussion about how to solve this problem. that has plagued and frustrated Democratic, Republican presidents alike. I'm going to introduce now our two majority witnesses, and Senator Durbin will introduce the Democrat. Professor Samuel Bray is a John N. Matthew Professor of Law at Notre Dame. He's a leading expert on law of remedies and the law of equity, and he's been cited by many Supreme Court justices, including Justices Thomas, Gorsuch, Kavanaugh, and Jackson. He's also been cited by both the Trump and Biden administrations. Professor Bray has written extensively on the topics of universal injunctions, including his Harvard Law article that goes by the title of Multiple Chancellors Reforming the National Injunction. Professor Bray is an elected member of the American Law Institute and is an advisor on the restatement of torts remedies. Jesse Panchuco is a partner at Boies, Schiller, Flexner, and co-leader of the firm's appellate practice group. He previously served as acting Associate Attorney General at the Department of Justice. Before that, he served as then Governor Rick Scott's General Counsel. He's also a member of the Administrative Council of the United States. I'm very interested in hearing both of your remarks today, and thank you very much for coming.